Mr. Chief Justice, and may it please the Court. The principal purpose of the government's appearing as amicus in the present case is to preserve the vitality of a legal doctrine which is not itself technically at issue in the case, but which the opinion of the court below, if accepted by this court, would effectively destroy. I refer, of course, to the restrictive doctrine of sovereign immunity, under which it is not all of the activities of a foreign sovereign as to which that sovereign will not be held accountable in our courts, but rather only those activities which are of a governmental as opposed to a private nature. At the time the famous Tate letter was issued by the State Department in 1952, that modern doctrine of sovereign immunity had already been adopted by virtually all of the important trading nations of the West. The significant exceptions were England and the United States. Since that time, only last November, in the Philippine Admiral case, the Privy Council has made it clear that England is no longer an exception. It has likewise been assumed that the United States is no longer an exception to the restrictive theory of sovereign immunity. Although the matter has never reached this court, it has been considered a number of times by lower federal courts and by state courts. Their decisions are uniform in accepting it. In view of those decisions, in view of the Tate letter, and in view of the deference which this court has normally accorded to the State Department's views in this area of sovereign immunity, it has, I think, properly been assumed that the applicable United States law does adopt the restrictive theory of sovereign immunity. Respondents have not asserted sovereign immunity in the present case for the obvious reason that the assertion would not have been permitted under the restrictive theory. There are several other reasons why the assertion may not have laid as well. But clearly there was no way in which the merchandising of tobacco or the receipt of an erroneous payment in connection with that merchandising activity could have been considered a governmental activity rather than a commercial activity on the part of the respondents. That being so, it would surely reduce the law to ineffectiveness and perhaps expose it to ridicule if the respondent, having been denied the claim of sovereign immunity, were able to achieve precisely the same result by simply appearing and repudiating the obligation as to the very acts on which the claim of sovereign immunity was denied. Nothing occurred in this case except the appearance of an attorney who, instead of asserting any sovereign immunity, simply asserted that the government of Cuba would not honor the obligation. And what is claimed is that the effect of that statement should be the same as far as the rights of these parties are concerned as the assertion of sovereign immunity under the old absolute theory. Respondents' reply brief seeks to calm our fears on this point by assuring us that repudiation of a commercial obligation will be unlikely. The respondent says, and I'm quoting his reply brief to the government now, it is only in the unusual case, and we suggest primarily in the political case in which this defense is called upon, that is, the act of state doctrine. He continues, it is likely that the more naked the repudiation, that is, the more unconnected with governmental functions, the more political the background. The trouble with all of these hopeful assurances is that they are destroyed by the experience of this very case. There could not have been a more naked repudiation, the mere statement of counsel in the case. And as to the high political background of the repudiation, its non-existence is shown by the fact that up until the point when it was discovered that we were talking about a lot of money, Cuba was willing to stipulate on the point, and indeed did so. That was one of the issues below. So there is no high political background here. It is simply a question of a lot of money. And until it was clear that it involved a lot of money, Cuba didn't care about the point. I suggest then that despite what respondent asserts in the reply brief, if the theory of active state that respondent is arguing in this case is adopted, that we can expect the state trading nations to use it precisely where they previously used the doctrine of absolute sovereign immunity, that is, wherever they do not wish to be held liable. How then can one avoid this absurd result of, on the one hand, saying the foreign state has no sovereign immunity, but on the other saying, which means the sovereign must simply appear and say that it doesn't want to pay? In the view of the United States, it is difficult not to avoid that result. If one simply regards the statement and the application of the active state doctrine as it has historically been described and applied by this court. Respondents would have us believe that the active state doctrine applies to all acts of a sovereign power. But whether one chooses the old cases or the new ones, whether one takes the formulation in Underhill or in Sabatino, the description of the doctrine has always shown that this is not so. There have been qualifications, not simply a statement that an active state is not examinable. In Underhill, for example, the doctrine of active state was described as applicable to acts done by sovereigns within their own states in the exercise of governmental authority. Two qualifications: in their own states and in the exercise of governmental authority. In Sabatino, it was described as being applicable to public acts of a recognized foreign sovereign power committed within its own territory. There are, in other words, two conditions attached. The first is the territorial condition, that the active state must have been performed within the government's own territory. One may interpret that territorial condition literally, I suppose, and if it is interpreted literally, the only active state that appears on the record in the present case occurred within the United States, consisting of the statement of counsel for Cuba. There is no evidence of any other action on the part of the government of Cuba. The government, the United States, as described in our brief.
Mr. Scalia, is that statement of the lawyers contradicted any place up until now?
No, sir. I don't believe there was any contrary evidence adduced to show that the lawyer was not authorized. And I think
As of now?
I believe that is true as of now, yes, sir. I don't think that the issue of whether the statement of the lawyer was in fact authorized is really present in this petition. Of course, if he were not authorized, then the matter would be much simpler. But for purposes of the present case, I think it is assumed that the statement was authorized to be made by Cuba, but nevertheless, the only act of Cuba...
Was the statement made to authorize it made in Cuba?
I don't know, sir. I don't believe there's anything in the record which shows where...
You say it's here, but the statement was that something was done in Cuba.
Well, certainly something was done in Cuba, but I would not consider a government...
Well, has the government got any contrary evidence of any kind? I would assume they would have shown it.
Contrary evidence to what effect, sir?
The fact that he wasn't talking about the truth.
Yes, I think that's correct. I think...
The fact that the government hasn't produced it after all these years leads me to what conclusion?
I think the conclusion that the statement of the lawyer was authorized. And again, I'm not contesting that. But the point is, the only action, the only public act committed by Cuba, as far as we know, surely the authorization to the lawyer, even if it was given in Cuba, does not constitute a public act any more than the authorization by the president to one of his delegates in the United States for that delegate to do a particular act constitutes the act itself. The act is...
Now that I've interrupted, ask one more question. Do you want Sabatino overruled or not?
Yes, sir. Well, I think as described in the government's brief, we think that the issue of Sabatino is not involved in this case because the active state doctrine properly understood, is not involved in this case. There was no act of state. Therefore, there is no reason for Sabatino to be presented to the court in this case. If, however, the court should disagree with our interpretation of the act of state doctrine, and if the court should find that when Sabatino spoke of an act of state, it meant an act of state which could even consist of a simple repudiation of a contractual obligation, then I would assert that Sabatino should be reexamined. But on that point, whether a commercial act can be an act of state. But in the view of the government, there is really no need to get to that issue because it would be reading Sabatino to be unnecessarily wrong if one were to read its description of act of state to include this simple repudiation. As I was saying, the court's decisions and the application of the act of state doctrine have brought forward two conditions: the territorial condition, which can be interpreted literally, or, as the government suggests in its brief, perhaps can better be interpreted not literally, so as to mean the act of state must be committed within the territory of the state, and if it is committed within that territory, that is enough, and if it is not, that is absolutely conclusive that there is no act of state. Rather, we think that the expression of territoriality is really a description of the most common situation in which the foreign governmental act constitutes an act as to which there is such a preeminent claim of the foreign government to exclusive legislative jurisdiction over the matter that the courts of the United States should not interpose our reexamination of that foreign state's action. But it is the second qualification to the act of state doctrine, which is, I think, squarely raised in the present case and which is of most importance to the government. That is the qualification that the act of state is an act performed in the exercise of governmental authority, and that it is a public act. Respondents would have us believe that these qualifications mean nothing, that they are mere surplusage, and entirely redundant, that when one says act of state, one has said it all. So long as the state has acted, that is it. But the cases haven't described it that way. They have felt constrained to say an act of a state in the exercise of its governmental authority, or to say public acts of a state. I would assert, to the contrary of respondents' contention, that it is not the government's position on this matter that is new or novel. What is truly novel and inventive is the repudiation which occurred in this case. If the act of state doctrine indeed were understood to be, as respondent represents it, it is indeed marvelous that such a repudiation before an American court has never, to our knowledge, previously occurred. That is the novelty in the case, not the government's assertion of what I believe has been understood to be the correct interpretation of the act of state doctrine. We assert, in other words, that the decision of the Second Circuit in the Victory Transport case, which involved precisely this issue, whether the denomination by a state of a port in a commercial contract as a safe port amounted to an act of state and therefore could not be reexamined in litigation. The Second Circuit held, of course, that the denomination of a safe port in a contract is a commercial act which merchants do all the time. The mere fact that it was done by a state or by a state trading agency makes no difference and does not prevent the government from, does not prevent the courts from inquiring into the case.
In this case.
Excuse me, sir?
Did that opinion, you said that was also a Second Circuit decision?
Yes, sir.
And did that opinion address any distinction?
That was an earlier opinion, sir. Yes.
The State Department took the position that they weren't going to intervene because the court matter was pending. Sabatino. The court asked for the State Department's opinion, and the State Department said, since this is a court matter, we won't give you our opinion. You remember that?
Yes. The position of the State Department in the present case is it has not sought to intervene in the present case either. The position of the government on the matter is simply that the interpretation we are urging of this act of state doctrine is in the interest of the executive branch and should be adopted by the courts for the simple reason that the two purposes sought to be achieved by the act of state doctrine are neither of them served by application of the doctrine to commercial transactions. Because if you are concerned about, first of all, the avoidance of embarrassment to United States foreign policy, the Tate letter makes it clear that there is no such embarrassment in the case of commercial transactions. And it's made further clear by the appendix to the government's brief in this case. The second purpose, the purpose of enabling the court to avoid cases which do not have manageable legal standards, that purpose also is not served by adopting an act of state doctrine in the commercial field, which is almost the prototype of a field where there are manageable legal standards.
Mr. Scalia, does any country that you know of concede or admit today that it applies the act of state doctrine to commercial transactions?
It is said that the act of state doctrine is applied by a number of other countries, but their application is a good deal less clear than our own has been. And I am unaware of any statement by another country that it applies to commercial transactions. I'm just guarding that statement with the fact that I tend to think the application by other countries has been a good deal less rational than or at least their description of it has been a good deal less rational than our own in any event.
You mean generally?
Generally.
In its application, perhaps without conceding that that in fact is what is being done.
I am certain that there are cases in foreign countries in which, in a commercial transaction, where what respondent in this case would call an act of state has occurred, the foreign court has given no regard to any, has not given it any special treatment. I see that my time has expired. Thank you.